Hey, welcome to this episode of the Terry Gorry Show. I'm a solicitor in Enfield in County Meath, and I, at the moment, take a look on a weekly basis at legal issues which pop up in the news, or particularly with reference to my Twitter feed. So that's essentially, I take a look at my Twitter feed. I have a feed set up for legal related tweets, and I take a look at it every week and see is there anything that you and I can learn from the Twitter feed. You might find it unusual or surprising that Twitter can be of any benefit to anybody, quite frankly, but from time to time there is some gems in the sewer, as it were. First thing I'm looking at there is a tweet to do with a child being awarded 19,000 euros for psychiatric injuries due to seeing his mother bleeding, and the judge approved the award of 19,000 euros. A court has to approve all injuries in relation to minors, but the judge awarded or approved this award of 19,000 euros and found it to be satisfactory and adequate. The mother, on the other hand, wasn't happy. She estimated the injuries at up to 60,000, but that's the position. The award was approved by the judge and therefore it's accepted. The big story in legal issues this week, or to do certainly with employment law, would be the whole question over the COVID-19 virus, and that is the question surrounding employment law, the obligation to pay. If employees, for example, are self-isolating, the employees may be encouraged, may be told to stay at home. Are they going to get paid in those circumstances? And the balancing of, on the one hand, employment law rights and obligations, and on the other hand, health and safety obligations. Clearly, every employee has a duty from a health and safety perspective not to bring a virus, particularly COVID-19, into the workplace, and therefore they have a duty on the one hand to stay away and to self-isolate and take the best medical advice from the Department of Health and from the government on the one hand, and on the other hand they may well be very much in need of the regular weekly income. We all are, and so there's a balance there between the employment rights and obligations on the one hand and the health and safety aspect of self-isolation and staying out of the workplace and not allowing COVID-19 to spread. There's a huge amount of sort of advice and people out there giving advice, and what I would recommend you to do is to go to the Workplace Relations Commission. I see from Ingrid Miley's RTE correspondent, she's a tweet there about the Workplace Relations Commission, and the Workplace Relations Commission have issued guidance for employers and employees. If you go to workplacerelations.ie, you'll find their guidance note, and they go through the various aspects of Self-Isolation, Safety, Health and Welfare at Work Act, the entitlement to be paid, and so on and so forth. It's a very useful guide. It's only a number of paragraphs, 10 or 15 paragraphs, 10 or 15 bullet points. You'll go through it very, very quickly. It's good guidance for employers and employees. It's on the workplacerelations.ie website, so go to workplacerelations.ie and you'll find that guidance for employers and employees, and you might get some clarity about payment obligations in relation to COVID-19, staying at home, self-isolation, being ill, preventing becoming infected, and so on and so forth. There's another tweet there from the Law Society of Ireland to do with employers who receive a protected disclosure must approach the issue with great care, and that's an article I think there that they're referring to from another firm of solicitors. And the reason, of course, why employers must take protected disclosures with great care is that the penalties for employers, if an employee is either penalised or dismissed for having made a protected disclosure, can be up to 5 years' salary. 5 years' salary in any man's language is an eye-watering sum of money. So that's why employers do need to be aware, do need to be careful if an employee does bring a protected disclosure. I would caution, however, it's a protected disclosure that you need to be concerned about. A grievance or a complaint or something else in the workplace isn't necessarily a protected disclosure, and there is a lot of confusion sometimes, particularly in the minds of employees, as to what's a protected disclosure and what's essentially a grievance or some other complaint to do with their employment terms and conditions. I see a tweet there from the Irish Times: boy bitten in face by a dog secures €78,519 settlement. The boy was aged 10. He bent down to pet the dog, and the dog unfortunately leaped up and bit him. It's a very sad case. 78 grand is not going to be worth a crap to the kid if he's scarred for life, so that's unfortunate. But in the courts situation, the law can only go so far, and sometimes injuries that you might suffer, for example the loss of a limb or something of that nature, simply money is not going to bring it back, is not going to fix the situation, and all the court can do is reflect, I suppose, its abhorrence at the behaviour and try to ameliorate the injuries suffered and make things a bit easier in terms of getting on with life. But obviously that 10-year-old boy, James Holden, 78,000, that's tough. I'd say his mother and his father and he would swap the money to have avoided that. There's a tweet there as well from some guy about a New York Post report where it says that Americans are actually avoiding Corona beer amid the coronavirus outbreak. Survey finds. So again, I suppose if you think about it, it's hard to assess exactly how people might behave or the views they might have, but any country, any populace that's capable of appointing or electing, I won't go further. The question of coronavirus is coming up there again. There's a lot of useful guides, etc., but I would recommend strongly going to workplacerelations.ie. It will have a good handle on the whole question of payment and employment law, etc. There's another tweet there from the Law Society. It's a practice note from the Taxation and Conveyancing Committee giving guidance on the young trained farmer relief. So there is relief there for young trained farmers, I think, when they get a site or receive a gift of a site or land from a parent. There's certain reliefs that they may be able to avail of if they're considered to be young trained farmers. That's something that's worth looking at if you are a farmer and if you are going to be receiving land to carry on as a farmer. And quite frankly, the definition of a farmer in the legislation could be fairly broad. So it's possible that land would pass from a farmer to a son or a daughter, and perhaps the son or daughter may not be actively engaged in farming. Not 100% about that, but it's something that worth looking into and considering. There's a question there or a tweet there about a postal worker bringing a damages action against An Post over tiger kidnapping situation. So obviously the masked raiders tied up Susan Byrne and husband. Not sure how that's going to go. I would imagine it'll probably be settled, but again, the question of negligence and the question of liability is one that's probably going to be at issue there as to whether the bank would be, or whether the postal company An Post would be liable for the criminal behaviour, etc., of people who would carry out tiger kidnappings. But clearly it would depend, I suppose, on the circumstances and what, if any, warnings might have been given and whether it had occurred before, and all sorts of factors. One other thing there that I saw, it was a piece of advice from a judge to do with litigation, and it's in the Law Society Gazette, which we get every week or every fortnight or whenever it comes out. It's useful, has useful articles for solicitors. But the judge makes the point, it's Judge McMenamin, I think, makes the point that he got very good advice when he was a young barrister from a solicitor who basically said to him that the value of a good letter or letters prior to entering into or commencing legal proceedings is not to be underestimated, because the judge makes the point that a court will look at the correspondence that has arisen around the dispute, and who essentially has been trying to resolve the issues, and who has behaved reasonably, and who hasn't been amenable to reason and settling whatever dispute is at issue. And the question of the correspondence is an important one, and he makes the point that firstly, the letters may prevent going to court at all in terms of legal proceedings, may help to settle the situation and compromise it. But if legal proceedings are later commenced, the correspondence that you might have engaged in, the letters that your solicitor or you might send, could be very useful to be able to open correspondence to the court and say, look, I'm coming here with clean hands, here's my correspondence, I was at all times trying to resolve this and I was being reasonable. This is useful to a court according to the judge, and you can imagine how that would be the case, because if you look at the correspondence leading up to a dispute or a row, it doesn't take too much mental energy or intellectual prowess, as it were, to ascertain who's being reasonable and who's not being reasonable. I hope you find this video useful. If you do, give it a thumbs up down below, and you may be interested in subscribing to my YouTube channel, in which I attempt on a weekly basis to explain various aspects of Irish law and Irish business. Thank you for watching.